This is Michael Popok, Legal AF, with a deep dive of what happened today with the Appellate Division First Department bailing out Donald Trump and allowing him to just post a $175 million bond rather than the $465 million or more that is generally required in order to stay the enforcement of the civil fraud judgment against him. I'm not only going to talk about the why, but I'm going to talk about the ramifications of it and what it did not stop. I want to be clear so that people have this information without blowing smoke or sunshine about what the appellate order that was a surprise to most, including me, what the appellate order did and what it did not do and what it means for Donald Trump moving forward. Let me just give set the stage first with what happened, and then I'm going to talk about what didn't happen. What happened was Donald Trump filed an emergency appeal. We weren't sure it was going to get granted in time, but today, the day that he needed to post his bond, the appellate division, led by the chief judge there, Judge Renwick, and four other of her colleagues got together and they issued the order. The order said that as long as Donald Trump posts a $175 million bond, lowering his requirement by more than $300 million, that would be sufficient for them to stop the enforcement of the judgment, meaning that Letitia James, the New York Attorney General, can't move forward in any way to execute her judgment on behalf of the people of the state of New York against any assets, real estate, bank accounts, boats, planes, and automobiles of Donald Trump. There's conditions. In order for that to happen, Donald Trump has to post by April the 4th, 10 days from the date of the order, that amount of money, that $175 million, either by cash or he's got to get a surety, a bonding company to post the bond for him. Let's assume he does all that. If that happens and he properly perfects his appeal, and that's what we call it in the appellate world, perfecting the appeal means you submit not only your notice of appeal, which is already done, but your first brief. First brief for Donald Trump for the September term of the appellate division, because the appellate division runs on terms, and the September term is when Judge Renwick has ordered, by way of her order today, has ordered that Donald Trump have his appeal perfected by. That would require a brief to be filed by July the 8th. July the 8th for the first brief. Then we'd have the opposing brief by the New York Attorney General, followed by a reply brief, the record, and the oral argument, a return date in September. That all has to happen. So two major things have to happen for Donald Trump. Post the bond by April 4th, $175 million. First brief in by Donald Trump no later than July the 8th. Now, if he does all of that, as I've said in a prior hot take, then all of the efforts by the order, but only the efforts of the order addressed to the Donald Trump, Alan Weisselberg, Jeff McConney, and the Trump kids, as it relates to their not being able to be an officer or director or be able to take out bank loans in New York. That aspect of the order, the original order by Judge Engoron, the trial judge, is stayed, meaning they can stay in their positions. Donald Trump can run his company with his children from now through the appeal. But what wasn't stayed is probably more powerful. No other aspect of the decision and order and the final judgment of Judge Engoron was stayed. His decision to have a monitor, a former federal judge, sit on top of Donald Trump and all of his assets and all of his financial dealings for the next extended 3-year period with robust new powers is not stayed by the appellate division. That's not stayed. Nor is the requirement that Donald Trump immediately create a new independent compliance director, an ICD, who will work with the monitor in order to help run that company properly and make sure it's interacting with counterparties in the world without committing further fraud. None of that has been stayed. Now, Donald Trump just got the order, this kind of enhanced monitorship order, just a week or so ago. Could he appeal that to the appellate division? Yes. That technically was not part of the appeal that has just got ruled upon because the order hadn't come out yet. But for right now, the monitorship with all the enhanced powers to in a proctologist-style manner, get inside all of Donald Trump's business affairs and trust affairs and all of his companies in operation, that is still fair game, not been stayed by the appellate court. subject to a future potential appeal by Donald Trump. Now, if I'm Donald Trump, having just gotten a bit of a win and a bit of wind at my sail from the appellate division and the chief judge, I might move again on the new monitorship order. But he's got to balance that because the appellate division, which is the intermediary appellate court that sits over the Manhattan trial court before you get to the highest level court in New York, the Court of Appeals. They took a look at the decision and order and no other aspect of it, including Judge Engoron's decision to create the independent compliance director, to have enhanced monitoring powers that were reflected in that judgment and order. None of that has been stopped, stayed, or overturned by the appellate division. They're just going to keep the personnel in place. They're going to let them borrow money from New York banks, subject to going through and jumping through all the hurdles of the monitor, Barbara Jones, and they're going to lower the amount of the bond from about $550 million or more with running interest down to a set number of $175 million, as long as it's posted in cash or in a bond amount by a surety company by 10 days from the date of that order, which is about April 4th. Okay? But I wanted to kind of make clear about what happened and then what didn't happen. Monitorship still in place. Donald Trump has to perfect his appeal, which he will by filing a brief on the 8th of July. He's got a hearing, an oral argument in the September term of the appellate division, now set by this order. They've already told him they're going to hear the whole case in September. So in terms of somebody who practices regularly in New York, from March to September, is that unusual? It's a little long in the tooth, to be honest with you. I've seen faster appeals than 6 months from now to get his appellate papers done. It's a little long. They could have done it like over the summer. I would have thought they would have picked maybe a July date, let him brief now. But I think they're also concerned about in New York itself. He's going to start a trial soon in the spring of 2024 in front of Judge Merchan for criminal fraudulent business records there. So I think they're sort of mindful of that he's going to be a little busy, Trump, in April, May, and then he's got another criminal trial after a Supreme Court issue that's going to be heard on immunity in April. Maybe that trial is in the summer. He's got Mar-a-Lago. Fani Willis, the Fulton County DA, says full steam ahead for August. So they're like, why don't we see you in September? It's like the old song, see you in September. I think that went into it. Look, they're judges, but they're human, and they read the paper and the media. And I think they know what the trial docket, civil and criminally, looks for Donald Trump. And they sort of didn't want to get in the middle of that propeller, and put it far enough out that nobody could argue about it being a mean-spirited setting of the date. Not that we should care about that, but that's where it's going to be. July 8th, filing Trump. September, hearing after full briefing, oral argument at the Appellate Division, First Department. Whoever loses that is going to take it to the Court of Appeals. It'll put it after the election. Won't necessarily be stayed in any way. Even if Donald Trump somehow were to pull out a miracle and win the election, shouldn't be stayed. But that's the timeline I want you to be aware of. So the takeaway on this hot take is, yes, bad news. Appellate court for no good reason, as far as I'm concerned. I saw the papers filed by Donald Trump. I didn't think much of them at all, nor that they were supported by proper evidentiary support or by proper affidavits or declarations under oath. But the Appellate Division, First Department, Barbara Renwick presiding, thought differently and has lowered by a lot, 60%, the amount of the bond that has to be posted by the 4th of April, and a requirement that the appeal be perfected for the September term. If Donald Trump does all that, he doesn't have to worry about his assets being seized anytime soon, but he's not out from under the monitorship because the appellate court looked at the monitorship and implicitly blessed it because they didn't remove it. They didn't stay the monitorship. They didn't stop the monitorship. They didn't stay the creation of an independent compliance director. They didn't stop that. That all continues. They're just going to allow Donald Trump to go to the bank and ask for money. They're going to let him run his companies in the meantime. They're going to let Jeff McConney and Alan Weisselberg, whenever he gets out of jail, because he's going to jail again, to serve as New York corporate officers and directors, same as Eric and Don Jr., subject to what happens off the appeal in the fall. We'll continue to follow it. I'm doing it from the lens of a practicing New York lawyer for over 30 years, including creditors' rights, this kind of law in these kind of courts. I do it exclusively one place, the MeidasTouch Network, and on Legal AF. That's our podcast. We named it for a reason. It's every Wednesday and Saturday at 8 p.m. Eastern Time, and then on audio podcast platforms of your choice, wherever you get your audio podcast from. And then we do hot takes like this one at that same intersection of law, politics, and justice. And we've got ways to support the show and Legal AF. We have a little bit of a Legal AF TED Talk that we've created on Patreon that you can go to patreon.com/legalaf and find us there for some more exclusive content. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.